Hi friends, this is attorney Marina Shepelsky. Today I want to discuss what happens when your loved one, the beneficiary of your family petition, gets denied, whether it's in USCIS or at the consular post, and the officer says you will need a waiver. We will discuss the I-601, I-601A, and the I-212 waivers, and when do you need to present them, and what happens. Before I start, if you like this type of content, please subscribe, become a follower, hit the little bell below, and give us a thumbs up to show us that you like this content, because myself and my team, we work really hard on these videos. So, when do you need the waiver? As I mentioned, when you are denied for either some kind of violation of immigration law, it could be a crime, it could be that you were in the US and you overstayed, unlawful presence, it could be a mistake, omission, lie, or fraud, and that's called misrepresentation and fraud in the forms. So you gave some wrong information or false information in your forms. It could be a medical reason that you need a waiver, or it could be that you helped, the person helped smuggle somebody into the United States. It often happens with parents who bring in kids across the border illegally. So there's a bunch of reasons why somebody will need a waiver, but at the end of the day, you have to decide with your attorney, because this is super complicated, if you will need the I-601, I-601A, or I-601 with an I-212 waiver. Now, you need two waivers, the 601 and the 212, where you have both the issue of the problem, right? Let's say it's misrepresentation in the form, and the person was removed from the United States, whether they were deported, by USCIS, by ICE, that is, or whether they left on their own and self-deported, or whether they were turned away at the post and given like expedited removal. That's considered removal or deportation. And if there was a deportation or removal, you need the I-212 waiver to overcome that by itself without the underlying problem. And now you will need to overcome the underlying problem, the misrepresentation or the unlawful presence, with the I-601 waiver. The 601A waiver is for people who are in the US, they have unlawful presence, and they need to go to their country because maybe they came without a visa for the consular interview, and they're afraid to leave without being assured that they will be allowed to come back. That's when we do the advance waiver, the I-601A, to make sure the person leaves, goes to the consular interview, gets their petition approved, and already has the permission to return. That's the approval of the I-601A waiver, okay? The I-601 waiver is pretty much for everything else that falls into these violations categories. How do we present this waiver? First, we determine that the beneficiary has a qualifying U.S. citizen or green card relative in the U.S., and the waiver is written from that person's perspective, not from the immigrant who violated, but from the suffering U.S. citizen or green card holder's perspective. The qualifying relative has to show extreme hardship. It's a legal term, which means they're suffering in the medical, psychological, financial, or like educational and other special circumstances areas is worse than everyone else. Basically, the waiver is an explanation by the citizen relative or green card relative why they would suffer if they're not allowed to be reunited with their relative, the beneficiary immigrant, and why this suffering is worse than everyone else. So we start with the medical. You will need medical records. You will need a psychologist letter. Then we'll move on to the educational. Perhaps, they have a good job or they're in school in the U.S. and they cannot do this in the home country if they had to leave America and go live with their husband, let's say immigrant, in the other country. Financial. Maybe they need the financial support from the immigrant. And special circumstances is everything else, and the equities here mean, look, maybe the guy goes to church and he's a good person. He has ties to American society, to a country here, kids, goes to church, has a good job, and so on. So we go through all of those categories and we write a statement, an affidavit from the qualifying relative. It could be 2 or 3 qualifying relatives. Then we write 3 affidavits. We always include a statement from the immigrant violator themselves saying how sorry they are, but it shouldn't be long. It should be 1 or 2 pages at most. They regret what they've done and how they've rehabilitated is very important to say. I've gone to church, or I've done this, I've done that, I volunteer, like they're a good moral person, they're sorry for what they did, and they've rehabilitated since then. They've realized the mistake. And at the end, we put an attorney brief on top of all this. So with the attorney brief, we'll say, okay, legally, these facts fit into these precedents. These other cases or these statutes that will allow our client to win here. Attorney brief, affidavits, records go as exhibits, as our evidence. The form goes on top, I-601 and maybe I-212 waivers. We pay the government fees. We send this out to USCIS. That might take a few years, literally, to get approved, 2, 3 years, hard to say sometimes. Once it's approved, we allow the embassy to know. We inform them that this is approved and they should schedule for an interview to follow up. And that's when they will actually consider for approval once they have the waiver approval. So this is briefly how this process works. You will definitely need a lawyer. We've done many of these very successfully, and we urge you to call us today for your waiver case and sign up with Shepelsky Law Group by starting through a consultation. Give us a call today. Thank you for listening.